But you see it as a possibility if he wants to spend $1 billion beating this guy, he could do it.
Absolutely. Somebody tweeted recently that he could have given every American $1 million.
I've got it. Let's put it up on the screen. When I read it tonight on social media, it kind of all became clear. Bloomberg spent $500 million on ads. U.S. population 327 million. Don't tell us if you're ahead of us on the math. He could have given each American $1 million and have had lunch money left over. It's an incredible way of putting it.
It's an incredible way of putting it. It's true. It's disturbing. It does suggest, what we're talking about here, which is there's too much money in politics. And it makes it difficult because...
Don't you have anything relevant to say?
Don't ask me. I'm just a girl.
Things are going to start happening to me now.
I think Tyler is amazing.
And I'm a fan of this show. I've watched several episodes.
Thank you, Tyler. Thank you, Tyler. You stink, Tyler.
Never promise crazy a baby.
Oh, I like that. That's a cool idea.
Are either of you homosexuals?
I go both ways. What do you think?
You mean like flaming or?
No, we're not homosexual, but we are willing to learn.
But I do wonder, for others, in other cases, whether libertarianism today is just an excuse for many on the right to act selfishly.
Look at me. And then some fat asses in Washington started having opinions. The Olympic Committee started having opinions. You bitch, I know you. You started writing your opinions.
And it just makes me wonder, you're dead, bitch. Why are you doing this to this poor guy?
I don't care. I'm a libertarian. What I'm getting is...
Did you vote for Joe Jorgensen or Trump?
Who?
Joe Jorgensen. That was the perfect answer. Thank you.
Hello, this is Tyler, LPR, episode 214, coming at you. We're going to do a little rape breakdown. I'm not feeling so good. So Hubbleson coming in and saying, hey, what's up, y'all? And, hey, can we get Madden on the telestrator for this breakdown? Yeah, it shows some turducken. Maybe that's the way we work at it. I hope everyone had a good Christmas. I'm a little, like I said, I'm a little on the ill side. I don't know what happened. Look, Tower Gang is tonight, so I had to come in early, come in hot. So we're breaking this down as best we can. I just saw this news and I thought it was something for us to take a look at. Hope everyone's doing good. Yes, let's check all the cameras. We're set and ready to go. All right. I thought first thing I would do though is talk about real quick let's go here. Hey, Lincoln says, hey, Tyler, hope you had a Merry Christmas to you and your fam. Get feeling better, buddy. Yeah, I don't feel horrible. It's just I have a sore throat. Not really sure what the dealio is. Not really too congested, but, luckily it's a Friday. I didn't get very much work done as a result. This is going to be actually probably a little tough for me to even do this. And then hopefully have the weekend to recover and then hit it hard for court coming up on Monday and some good things there. But what I thought we would first take a look at is we talked about the last episode. We talked about the Blake Lively issue, and then someone made a comment, and it immediately I was like, oh yeah, exactly. Here we go. Which is when you're going to, because these are under equal protection, employment, civil rights type of issues, and I did a few of these back quite a few years ago, but. What you do is, if you're going to go through the state side, like you have here, the DFEH, or the EEOC for the federal side, you file a complaint with either one of those bodies, and oftentimes they just take over the investigation and they go forward, and then you just kind of funnel your client that direction, and that's a great way to do it. You can still file a lawsuit, but if they're not going to do anything, then they issue out a right to sue. So those are the scenarios you got to go through. And that's what I missed on the Blake Lively issue when I was like, this is a little bit of a weird pleading. It didn't say what county it's in. Okay, well now it makes sense. Matter of fact, they might have gone overboard. When I did it before, you don't write necessarily an entire pleading and complaint like that. You could just draft it any which way you want, like letterhead type of thing. But they did it a little bit different. So it makes sense to me if you go back and watch the last episode. Now it all kind of comes back full circle. It makes sense. You either go through the Civil Rights Department of California, the DFEH, or the EEOC on the federal side, depending on which one you're going to go through, planning on going through state court or federal court. And they either take it up themselves, the Equal Opportunity Office or the Department for Fair and Equitable Housing. I think that's what that is on the California side. So those are just two options you got to have. And then anyway, it makes sense if anybody's out there wondering, hey, Tyler, you didn't know what the fuck you're talking about last time. Yeah, okay, could be. Could be. Okay, so let's talk about California Appellate Court overturns ex-49er Dana Stubblefield rape conviction. We're not going to play the little video there. Do I want to actually look at, there's the actual complaint. Let's do this. But okay, so federal court, and I thought we'd actually read through the complaint here a little bit for us to get a little excitement. But this was in 2020. I think that's when they had the court conviction case, but they've overturned it on an appeals issue. So we want to walk through it because it's somewhat fascinating. And let me see if I can I'll go to Twitter here because I think I had saved it as a bookmark that kind of caught my eye this morning. Here's how the San Francisco Chronicle is. Maybe we'll go back here. Here's how they're stating. The rape conviction of former 49ers player Dana Stubblefield, he was also a Raider. Let's make sure we know that, was overturned by a California appellate court Thursday after a panel of judges ruled the conviction was in violation of the California Racial Justice Act. So we're going to talk a little bit about that. We're going to walk through this thing. It is 30-some pages. I don't know that I want to read the whole thing that I can, actually, because I'm not, on the...
But you see it as a possibility if he wants to spend it.
All right, that bitch, by the way, I wanted to get real quick back there. I thought that was fascinating. If you saw the very open, which is her talking about the tweet, someone's like, Bloomberg, because it kind of resurfaced with people with Musk. Oh, they could afford to give everyone like $1 million. No, you don't do the math. It's like $1.43. Okay, these people are so stupid. But anyway, let's get to the complaint or the actual ruling on the appeals court, and there we go. I think that's what it is. See, this is more like what we were talking about the other day. That was things were missing. There's a file date on there. That's fine. The people v. Dana William Stubblefield, which county, the case here. Now this is an appellate court, so it's a little bit different. Let's read about the issue here, and then in his conviction, and then we'll talk about what they actually did. Defendant William Stubblefield is a black man, publicly known as a former professional football player in the NFL. Jane Doe, an intellectually disabled woman. This was a pretty ugly thing. Reported to police that Stubblefield raped her at gunpoint. I'm going to try to use words that I don't get demonetized for. When she went to his house in Morgan Hill to interview for a babysitter job, a jury. Why would you have a mentally disabled woman come into your house? First of all, to watch your kids. A jury found Stubblefield guilty of forcible rape, forcible oral copulation, and false imprisonment. The jury further found he personally used a firearm in the commission of the first two offenses. The trial court sentenced Stubblefield to a term of 15 years to life in prison. The prosecution alleged Stubblefield threatened Doe with a handgun while she was at his house. The police, however, had decided not to search Stubblefield's house after Doe reported the incident, and no gun was introduced into evidence. Okay, there's a reason why this all happened. In closing arguments, the prosecutor asserted the police made the decision not to search Stubblefield's house based partly on the fact he was a famous black man. The prosecutor claimed a search would have opened up a, quote, storm of controversy, unquote, and added, can you imagine in Morgan Hill when they search an African American? Whereupon defense counsel objected. The trial court sustained the objection, but gave the jury no admonishment or instructions with respect to this part of the prosecutor's arguments. Stubblefield contends the prosecution's statement violated the California Racial Justice Act of 2020, RJA. Closing arguments began July 21, 2020. Remember, this is all around the, as we saw in the Blake Lively thing, the civil rights protests, right? Which, in reality, it was just the BLM riots. 8 weeks after a police officer, they can say murdered because he was convicted of that, setting off weeks of massive protests and nationwide social unrest. A lot of violence. Stubblefield argues the prosecution appealed to racial bias by identifying his race as the reason for a weakness in the prosecution's case and tapping into a racially biased backlash against the protest. The Attorney General contends any violation was harmless beyond a reasonable doubt. Yeah, probably true. We find the prosecution violated the RJA, the Racial Justice Act, as codified in part of Penal Code Section 742. The prosecution explicitly asserted Stubblefield's race was a factor in the law enforcement decision not to search his house. That's really interesting. I mean, basically what they didn't want was you to burn down Santa Clara County in its entire, more than was already happening. The statement implied the house might have been searched and a gun found had Stubblefield not been black, and that Stubblefield therefore gained an undeserved advantage at trial because he was a black man. Second, the claim that a search would open up a storm of controversy implicitly referenced the events that followed George Floyd's then recent killing, appealing to racially biased perceptions of those events and associating Stubblefield with them based on his race. Now, I mean, it seemed like an open and shut case for the most part. They didn't really have to, the prosecutor didn't have to go down this route. But at the time, I mean, you gotta point out some things. Maybe we find the prosecutor violated the RJA. Okay, we said that, and then based on his race, we find the prosecution's statements constituted racially discriminatory language about Stubblefield's race within the meaning of the Penal Code 745, Subdivision 82, and we conclude his conviction was sought or obtained in violation of Subdivision A. We further conclude Penal Code Section 745, Subdivision E2A. Precludes harmless error analysis of this violation and mandates a specific remedy. So in other words, they can't just say, oh, we bypass this. I don't know what the code actually says. Maybe they'll read it out here that, harmless error is not, there's not something you could, it doesn't preclude it. We are required to vacate the conviction and sentence, find that it is legally invalid, and order new proceedings consistent with Subdivision A. Stubblefield contends the prosecution made other statements in violation of the racial RJA, and he further contends the prosecution violated his due process rights by making these statements. Stubblefield also raises numerous claims of error beyond the Racial Justice Act because we must reverse the judgment, vacate the conviction and sentence, and remand for further proceedings. We do not reach these claims. But are they going to retry him? Yeah, I think there's a good chance to retry him here. Procedural background, but he didn't get out for Christmas, so he's out just short of Christmas. But there you are. Procedural background: the prosecution charged him with 5 counts: forcible grape, count 2, grape of a victim incapable of giving consent. That's nasty. Forcible oral copulation, and count 4, oral copulation with a person incapable of giving consent, and count 5, felony false imprisonment. As to counts 1 through 4, the prosecution further alleged Stubblefield personally used a firearm in commission of the offenses. The trial began on March 2020, but it paused 2 weeks later due to the onset of COVID-19 pandemic. Jeez. Just L after L after L for this county. The trial resumed 3 months later. Yeah, it was like a 9-month trial in total. And in July 2020, the jury found Stubblefield guilty for forcible grape. Forcible oral copulation, false imprisonment. They also found Stubblefield personally used a firearm in the commission of the forcible rape. Count 1, in forcible oral copulation, the jury acquitted Stubblefield on count 2, incapable of giving consent, and count 4, oral copulation, incapable of giving consent. On October 2020, the trial court sentenced Stubblefield to an aggregate term of 15 years to life. That's a lot. The sentence consisted of a term of 15 years to life on count 1, a concurrent term of 15 years in life to count 3, and a 3-year term on count 5 stayed under section 654. Facts of the evidence. Stubblefield is a black man and a former professional football player in the National Football League. In April 2015, he was 44 years old, 6 feet 3 inches tall, and weighed about 340 pounds. He lived in a house in Morgan Hill with his wife and 2 children. Jeez. Jane Doe was an intellectually disabled 31-year-old woman living with her mother in Hollister. Her driver's license stated she was 5 foot 3 inches tall and weighed about 125 pounds. Doe alleged Stubblefield had her without her consent at her at gunpoint when she went to his house to interview for a babysitter job. Stubblefield argued Doe consented to sex in exchange for money. And you know how much he paid her? We'll get to that in a little bit. $80. Sorry to spoil it. Time limit of incident based on text messages. I kind of want to get to. So basically, he called her up there. She's I don't know, retarded person or whatnot. He has kids. Testimony of her. Let's get to some of this maybe. Prefatory note is necessary to provide fair and appropriate context for a summary of Jane Doe's testimony. Doe's scores and IQ tests were in the second percentile, and she suffered from a language disorder that hampered her ability to speak and testify clearly. Her responses to questions were often non-responsive, unintelligible, or syntactically fractured. At times, she could not verbally express her response, so she wrote it on paper. She appeared to have difficulty describing the chronological order of events or understanding how a question related to timing and sequence. Consequently, segments of her testimony are just difficult to understand or encapsulate. Nonetheless, the following narrative can be distilled from the transcripts with reasonable faithfulness to the record. According to her testimony, when she met Stubblefield at his house, he was the only one there. Introduced himself as Dana. He did not say anything about playing football. She did not recognize him or know that he had played football. First time she arrived at his house, he invited her into the kitchen, where they discussed his kids and the details of child care services she would provide. They anticipated that Doe would start the following Saturday. Stubblefield offered to pay her an hourly rate of $20 or less. They talked around 10 to 20 minutes, and Doe left. As she was driving away, he texted her to come back so he can give her money. She went back, and he invited her into his house and gave her $80. When she entered the house, he locked the door. He then picked her up, took her into a dark room that had a bed and a dresser. She told him no, and I don't want no money. She insisted she had to leave. He would not let her go. He took a photo of her driver's license and gave her $80. Solid man. Stubblefield pulled Doe's pants down and put her on the bed. She did not scream or try to fight him because he had big muscles. Doe told him she did not want to have sex. After pulling her pants down, Stubblefield pointed a gun at her and told her, "I'm going to kill you." Doe indicated that Stubblefield pointed the gun at either her lower stomach or her vagina. The prosecutor asked Doe what the gun looked like, and she responded, "Small black one." Sure, it was his gun. "I can't see, too dark." She thought he might have been hiding the gun in the dresser or in the bed, but she did not see where he got it from. Stubblefield then had sex with Doe. He put his mouth on. Okay, well, he did a lot of stuff here. Her statements to the police were generally consistent with her testimony, as summarized by the above narrative, but some portions of her statement and testimony were too ambiguous or confusing to allow for a meaningful comparison. On both occasions, she gave ambiguous or confusing answers to questions about whether Stubblefield paid her the money in exchange for sex. But, I mean, the problem you have is they prosecuted him on her not being able to consent. She's not smart enough to even consent. So you've got a problem even there, right? I don't know how she drove. Some parts of her testimony were clearly inconsistent in her statements to the police. Doe told the police Stubblefield had shoved a gun in her vagina. In the prosecutor's direct examination, Doe confirmed she told the police, yeah, other times he just shoves it in vagina. In cross-examination, what kind of person is this? What are we looking at here, ethnicity-wise? In cross-examination, Doe repeatedly denied making that statement to the police. In direct exam, the prosecutor asked Doe about her statement. She denied she told the police he put the gun inside her. The prosecutor then showed Doe a transcript to the police, and he verbally recited a portion of the transcript to Doe. Doe then testified that she did not remember that statement to the police. Defense counsel questioned Doe about 2 online campaigns she started, seeking monetary donations, GoFundMe website, seeking $14,000 by falsely representing she was sick with ovarian cancer, and another seeking $9,000 because her father had died, without disclosing the death occurred when she was a little girl. Solid. The parties stipulated that Doe's identity had been verified by GoFundMe and her bank account linked to GoFundMe, but she never received any money through those efforts. She repeatedly denied that she had set up the campaigns. After counsel continued to question her about a printout of the GoFundMe for the ovarian cancer campaign, she eventually admitted she had set it up. But she claimed she did not mean to do so. After this lady, that's tough. You got a mentally disabled, literally. Hang on, let me pull this one up here. Person, and you're... What in the hole did he put in? What hole did he put it in? Well, she said vagina. I'm just trying to be a little bit more lax here on our statements. After the court persuaded Doe to look, okay, so I'm not going to go through all the testimony. It sounds like there was troublesome issues there, but that's not why they overturned it. Okay. And the police not doing the right thing at the time and having the balls to go in and search and get the gun is problematic. But I also understand that they are like, we don't want to cause more issues here. But, do your shit. You're damned if you do and you're damned if you don't. The initial investigation regarding Stubblefield's identity. I want to get to the part where they talk about the legal aspects. Stubblefield's statement to the police. When interviewing the officer, Stubblefield hiring Jane Doe from the sittercity.com. He said he had contacted Doe, but she had never responded. He denied that Doe had ever been in his house. When the officers showed Stubblefield text messages between him and Doe, Stubblefield said she might have been a girl he had interviewed, but he could not remember her. When the officers asked Stubblefield about the text message showing Doe had arrived at his house, and the subsequent message about returning the money, Stubblefield said the text did not sound like his. And he stated again that he didn't remember her. He denied ever having consensual sex with any nannies who came for a job. Testimony under Evidence Code 1108, 2 witnesses testified that Stubblefield had sexually assaulted them. L. Doe testified that she and her 3 friends met Stubblefield in a club in 2006. At some point, her and her friends got into Stubblefield's limousine with him and some of her friends, and they went to his house. She was drunk. She was vomited in the limousine. Later that night, she was alone in the car with Stubblefield, and he was too intoxicated to move or speak. And she was. Stubblefield unbuttoned her pants, put his hand in her underwear, and okay, so he went down on her. R. Doe and several friends met him at a bar in 96, Super Bowl year for 95 for the Niners. Her husband was a fan of San Francisco 49ers, so she asked Stubblefield for an autograph. He told her he had something in the back of the bar and he would sign for her. This dude is a sleazebag. And they went to the dark kitchen area. He lifted her onto a counter, pushed himself between her legs and started kissing her. She tried to push him away, told him to stop, but he grabbed her arm and pulled her further into the kitchen. He ended up in an upstairs hallway where he pushed her onto the ground and got on top of her. I mean, he's a big dude, and his whole job is to flatten people on the field. He touched her breasts, under her bra, grabbed her inner thigh. She told him to stop, tried to move out from under him, but all his weight was on her. When someone came upstairs and saw them, he pushed himself off and left. Jeez. Government evidence. Here we go. The police never searched Stubblefield's house in Morgan Hill, and no guns were found at that location. Because they didn't search it. In the statement to the police in January 2016, I think that's when this originally happened, and then it finally went to court in 2020, Stubblefield said he did not have any guns. In April 2014, Stubblefield was living in San Jose when a police officer went to his house to recover a gun that was registered to him. 1 or 2 days later, Stubblefield gave the officer a gun. But the officer later realized it was a different gun, not the gun he tried to recover. The officer called Stubblefield back several times, but he never responded. And the officer never located the gun he tried to recover. Now, why was he trying to do this in 2014? Let me take a look here. I'm gonna see if we can possibly find the year that this incident happened. The case was in 2020. When was the procedural background? I'm trying to see the year that she said the events happened. 2015. Okay, so it was 2015 is when this happened. We did just talk about that. So the problem with that though is I'm just curious as to why they were trying to get a gun from him in 2014. Now the reasons you try to turn it, you have to turn in guns in California. Didn't she have Down syndrome? Possibly. That said she drove there. I presume the way they did the facts, it sounded like she drove there herself. So I don't know, but that's pretty. I mean, this dude, you'd think he'd be able to just afford a pro, right? Instead of, but he was used to working with 4 downs in a game, so maybe he just thought this was part of that whole situation. I don't know. But let's look back here. So 2014, Stubblefield was living when a police officer went to his house to recover a gun that was registered to him. Why was that the case? There's only a few things I know that reasons you have to turn in guns. One of those is a domestic violence restraining order or a criminal restraining order, civil restraining order. They put you in this CLETS system, and one of the first things you have to do is turn in your guns. We've talked about this on multiple cases with due process. I'm trying to remember the case that went up to the Supreme Court. That was that kind of issue where the idea is the standard to even get a domestic violence restraining order is so low, but then, to infringe on your rights for your gun should be heightened scrutiny. So there's a weird dichotomy between the two of them in there. So 2014, he's supposed to be turning over guns. I don't know why. Maybe there was a restraining order on him back in the day. The officer never got the gun. Stubblefield contends the prosecution violated the RJA during closing arguments. He argues the prosecutor explicitly and implicitly appealed to racial bias by arguing that police did not search Stubblefield's house partly because he was black, and a search would have resulted in a storm of controversy. Yeah, I don't know is that racial bias to him, or is that just stating the facts on the ground, right? Now, the fact that they didn't do it is problematic, or even why this prosecutor is stating this in court. Heading in the attorney general's, here's the deal. It happened. There was an objection. Over the objection, the judge let it through. So the ruling is basically that the prosecutor did this, but the judge allowed these comments to go through. Heading in the Attorney General's brief summary states that Stubblefield's RJ claims have no merit. But as to the claim at issue here, the Attorney General's brief does not support that position with any argument. He contends that even assuming there was a violation, it was harmless beyond a reasonable doubt. And this is where I have problems sometimes with, like you get a situation like this where the Attorney General is probably helped spur, or at least his side, Gavin Newsom here in California, push through this ridiculous Racial Justice Act, right? So the Attorney General doesn't really want it enforced, right? I mean, they want it enforced. They don't really want to have this as something that doesn't work. So they argue against it because they obviously, this is a guy that's going free on some pretty nasty accusation or convictions here, but they don't make much argument to it, right? Their heart's not in it, right? Been there before, but I'd still do a much better job than kind of what they than what they did. The California Racial Justice Act. The legislature enacted the Racial Justice Act through the passage of Assembly Bill 2542. That was in 2019 and 2020. The legislature passed the RJA in 2020 with a state aim to, quote, eliminate racial bias from California's criminal justice system, and to ensure that race plays no role at all in seeking or obtaining convictions or in sentencing. To that end, the RJA prohibits the state from seeking or obtaining criminal conviction or seeking or obtaining or imposing a sentence on the basis of race, ethnicity, or national origin. The RJA added Section 745 to the Penal Code, and the legislature has since amended Section 745 twice because they get shit wrong all the time. This subdivision sets forth 4 categories of conduct, which, if proven by a preponderance of the evidence, establish a violation. See, and that's problematic here too. You have a full issue of beyond a reasonable doubt, but within that you have a section that is just a preponderance of the evidence standard. You get these kind of things quite often. But this is the case concerns the use of racially discriminatory language in violation of Section 745. As relevant here, a violation has occurred under that subdivision if, during the defendant's trial in court and during the proceedings, an attorney in the case used racially discriminatory language about the defendant's race, ethnicity, or national origin, or otherwise exhibited bias or animus towards the defendant because of the defendant's race, ethnicity, national origin, whether or not purposeful. Yeah, I don't like that part. It should be purposeful. In relevant part, racially discriminatory language means language that, to an objective observer, explicitly or implicitly appeals to racial bias, including but not limited to racially charged or coded language, or language that references the defendant's physical appearance, cultural, ethnicity, or national origin. Subdivision A2 does not apply, quote, if the person speaking is relating language used by another in the relative case or that a person speaking or giving racially neutral or unbiased physical description of the subject. So a witness says, this is a black guy, you know, or it was a Orthodox Jew or something like that. Then you're like, okay, I guess that's what they're giving an exception for. Or as a white guy, of course, that's never going to be okay or not okay. As originally enacted, Section 745 only applied prospectively to cases in which judgment had been entered prior to January 1, 2021. This version of the statute enacted only applied prospectively to the cases in which judgment had not been entered prior to then. This version of the statute permitted defendants to raise a violation of filing a motion in the trial or judgment had been imposed by filing a petition for writ of habeas corpus or motion under section as a court of competent jurisdiction. The statute also mandated various remedies specific to the type of violation found and the procedural posture of the case when the violation was established. As relevant here, when judgment has been entered and the court finds, quote, that a conviction was sought or obtained in violation of subdivision A, the court shall vacate the conviction and sentence, find that is legally invalid, and other proceedings consistent with this subdivision. Okay, so they amended it. Let's keep going. They did it a second time. For claims based on the trial record, the defendant may raise a claim alleging a violation of subdivision A. I'm sorry, I'm having a tough time here. A direct appeal from the conviction or sentence. The statute now provides that post-judgment CRJA claims based on the trial record may be raised on direct appeal from conviction or sentence, including 2 cases with judgments entered before January 1. I mean, that's just, how far back are you able to go? That's pathetic. Law changes. They were convicted under a different law, and now law changes, and now you're going to, yes, Andy, this is your CEO issue. Yeah. Principles of statutory interpretation. When we interpret a statute, our fundamental task is to determine the legislature's intent so as to effectuate the law's purpose. We first examine the statutory language, giving it a plain and common sense meaning. We do not examine the language in isolation. Furthermore, we consider portions of a statute in the context of the entire statute and the statutory scheme. I'm not too interested in that part. Interpretation and application of the Racial Justice Act. Factual background, I don't really want to get into that. George Floyd's killing. Yeah, it's really to protect black people. And here we go. Not to protect the raped. Application of Racial Justice Act to the prosecution statement. Stubblefield contends the prosecution statements violated the RJA by appealing to racial biases and explicitly using Stubblefield's race against him. I don't know that it was. I guess it was being used again. Stubblefield points out the context in which this proceeding occurred. Closing arguments began July 21, 2020, 8 weeks after the George Floyd's death. I'm saying death instead of killing. The news and internet were saturated with scenes of conflicts between police, rioters, protesters, counter-protesters, fueling a racial-motivated backlash by those who blamed black people as the cause of the conflict. Not untrue. Stubblefield argues the prosecution's argument tapped into this white rage. Wow. So he can use racially charged language in his appeal, but they can't use it in his prosecution. I gotcha. By blaming Stubblefield's race on the flaw of the prosecution's case and implying that if jurors did not convict him, it would amount to letting him go free because he was a black man. The Attorney General contends any violation constituted harmless error. Before we address the merits of his claim, we consider whether and how the Poise-Floyd conflict would factor into analysis under the applicable legal standards. I don't think I'm going to like this part, and I may just skip over it, partly because I'm having trouble with my... Has rape been, I think you mean overturned? Yes. Lots of reading going on. What the hell is a Racial Justice Act? The Racial Justice Act is a bullshit California law. That's all I'm going to tell you. Yeah, I'm having trouble reading here too, Andy, with my throat. And you're going to say, you always have trouble reading. So let's just kind of get down to the nitty gritty here. Page 21. The prosecution statements violated the RJA. The prosecution explicitly mentioned Stubblefield's race twice. The prosecutor began describing, quote, some reasons why, unquote. There was no search of Stubblefield's house, starting with the fact that the doe had not identified Stubblefield. The prosecutor asserted a second reason, that police were aware Stubblefield was famous. The prosecutor then explicitly raised Stubblefield's race. Third, he's African American. Next, the prosecutor asserted, what they're really mad is here that he had, instead of white privilege, he had black privilege. Explicitly, and they pointed that out. This is a person with black privilege, and we didn't want you destroying our house, our city, because you have black privilege, especially in this area. You're famous. You're a black man. It's going to be on the news. You raped a retard, and now we're going to, because there's no common sense out there in this. So we didn't do our job. The police didn't do their job, which they let him off on they finally arrested him. But I'm just saying, they didn't do their complete job, right? And so then the prosecutor is going to make up excuses for the shitty police work, which is the police were giving him black privilege. And then when you mention that, it's all a problem. So, I get this is a stupid law, first of all. Second of all, prosecutor going about it this way. You didn't need to. There was more than enough evidence. And then the police not doing their shit and not controlling your cities. If you controlled your cities the way you should have, these big protests, and not shut everything down at the time. This all goes back to Newsom. That's where we should be pointing the guilt here. He closed down the businesses. He closed down everything, schools, everything, and then people decided, hey, we're not busy. We're getting free money. Let's cause some peaceful protests, and they destroyed cities. And with doing that, this is the kind of shit that happens. Rapists go free, right? Third, he is African American. Next, the prosecutor asserted an explanation for why these facts would matter to the police. So if you do a search on somebody's house with no ID, no real idea of the victim or who you're dealing with, that's just going to open up a storm of controversy. Yeah, do your fucking job. The prosecutor immediately followed this by asking the jury, can you imagine in Morgan Hill when they search an African American before the prosecutor was cut off by... where's the... Right, you got that one. What else do we have here? Right. Was cut off. Furthermore, the prosecutor was not related. Okay, the record clearly established several elements required for the violation of RJA. The prosecutor was an attorney in the case and made the statements in closing arguments during the defendant's trial in court and during the proceedings. Further, the prosecutor was not related language used by another in a relative case, nor can the statements be characterized as giving a racial, neutral, or unbiased physical description of the suspect. If this was in place at the time of Leo Frank, well, they were talking about that. They never went after him with that. They still would have been fine. The prosecutor did not use Stubblefield's race as an incidental fact that might make it relevant under racial neutral theory. For example, as evidence supporting a witness's ID of the suspect. Rather, the prosecution identified Stubblefield's race as a factor in law enforcement's decision-making, making it one reason why there was no search of his house. On its face, the argument defies any racial neutral interpretation, I guess. See what else. We're getting near the end. We're just going to roll down to the finish. And for these reasons, we find the prosecutor's statement concerning a storm of controversy viewed in the context of the surrounding language constituted racially discriminative language. Could be. The required remedy. Here we go. The Attorney General contends the RJA violations were harmless beyond a reasonable doubt. Stubblefield argues the RJA, as applied here, forecloses any prejudice analysis and mandates that we vacate his conviction and sentence automatically upon finding a violation of Section 745, Subdivision A. Except as set forth in this subdivision, mandates that if the court finds a violation in this subdivision, the court shall, quote, shall impose, which means they have to, one of several enumerated remedies specific to the violation. Subdivision applicable in this case provides after a judgment has been entered. If the court finds that a conviction was sought or obtained in violation of the subdivision, the court shall vacate the conviction and sentence, find that it was legally invalid, and order new proceedings consistent with the subdivision. I mean, this is tough because this is what's stupid about this, which is this law went into effect. I think they were saying, it was 2020. When was the law put into effect? I know it was right around the same time, but there was that 2021. They said it had to be after that point. So it's hard to do something under the rules of evidence that you're just fine on doing. And then a law goes in later, and then retroactively you're able to overturn it on something on a basically a technicality that was not a problem at this point. So I mean, if the state has any balls and they appeal this up higher, I don't know what's going to happen. It would be interesting to see if the California Supreme Court upholds this. Anyway, the plain language. Let's get to. Okay, here we go. The Attorney General points out that Section 745, as originally enacted, applied only prospectively to cases in which judgment had not been entered prior to January 1, 2021. Furthermore, the original version of Section 745 provided only two ways for defendants to raise a claim after the imposition of judgment: by filing a writ of habeas corpus or motion under Section 1473, Spot 7. The version of the statute did not include any provisions allowing for harmless error analysis. When the legislature first amended Section 745 through Assembly Bill 256 to make the RJA retroactive to all cases in which judgment is not final, the legislature also acted Subdivision K, requiring harmless error analysis for a certain class of petitions. Because the legislature enacted these changes in tandem, the Attorney General argues they reflect the legislature's recognition that it would be unfair to automatically reverse every case where the affected parties had no notice of the change of law. Exactly what I was saying. The Attorney General contends this unfairness principle applies equally to petitions, motions, claims on appeal. He asserts there's no logical reason why the legislature would intend Subdivision K to apply to petitions but not to claims raised on direct appeal. We are not persuaded. First, the plain language of Subdivision K is, and you're not persuaded. I'm not going to read it all. Disposition. The judgment is reversed, and we find the conviction is legally invalid. The conviction and sentences are vacated, and the matter is remanded to the trial court to conduct new proceedings consistent with Penal Code Section 745. Subdivision A. Well, there you go, people. A little disappointing, I imagine. Rape. Lots of reading going on. This is a clown show. Yeah, it is. Damn it. Didn't get notification on that. Yeah, sorry about this. I had to come in a little bit early because Tower Gangs tonight. I don't know if I'm going to be helping them. And I guess I should. I'm just not feeling well. So I thought I'd do this real quick. 35 pages. I skipped a lot of pages there. I would be interested to see if they're going to look. They gotta retry this guy. I mean, I'm sorry. This isn't one where you've served your time and now we'll let you. I mean, this is a dude. This is a bad dude. I don't care. Even as a Niner fan, I'm just like, and I enjoyed the many times, the Super Bowl there in '95. But dude is raping out there a lot, and it appears so. I mean, at least this time. I mean, a retarded chick. He's out there doing this, and that's just it's just not a good not a good look there, Stubblefield. So I don't have a lot of I don't have much sympathy for him. What else? We'll get to this last little bit. We'll read this through this here, and then maybe we'll take off just so I can handle my life. And Jay-Z gets post-Christmas coal as judge denies efforts to dismiss case accusing rapper and Sean Diddy Combs of assaulting 13-year-old in 2000. By the way, I just thought I'd say, okay, we'll start off with this. Less than 24 hours after Beyonce's triumphant Christmas Day NFL halftime extravaganza blew Netflix viewers' wigs off, a legal storm has hit Carter household as Jay-Z lost his Hail Mary attempt. This is all one sentence. Hail Mary attempt to terminate the case against him and the incarcerated Sean Diddy Combs that alleges the duo violently assaulted a minor more than 20 years ago. That was a lot. And by the way, sure, call me old-fashioned, call me a typical white dude, but I thought the Beyonce thing, and by the way, I was a little bit proud. My daughter, 22, she's just like, this is trash. She goes, these people are gross. My kids follow too much of the news and they know about these trashy people, Jay-Z, Beyonce, what creeps they are. So they were trashing them. I'm like, why? She kept pushing her crotch out there and her thighs are exposed. You can't ride a horse like that, whore. You're going to get all chafed down there. But it's what it is. So I wasn't impressed. I just never get impressed by that kind of halftime show. But evidently it was jaw-dropping. Everyone just loved it, right? I just hated it, honestly. In a withering, I would prefer the halftime show is just those stupid DEI people up there talking nonsense that don't know anything about football. Too many women. I get that. Let's play this intro one more time.
But you see it as a possibility if he wants to spend $1 billion beating this guy, he could do it.
Absolutely. Somebody tweeted recently that actually with the money he spent, he could have given every American $1 million.
I've got it. Let's put it up on the screen. When I read it tonight on social media, it kind of all became clear. Bloomberg spent $500 million on ads. U.S. population 327 million. Don't tell us if you're ahead of us on the math. He could have given each American $1 million and have had lunch money left over. It's an incredible way of putting it.
It's an incredible way of putting it. It's true. It's disturbing. It does suggest, what we're talking about here, which is there's too much money in politics. And it makes it difficult because...
Don't you have anything relevant to say?
Don't ask me. I'm just a girl.
Exactly. And by the way, the math was wrong. The math wasn't, oh, yeah, it's right. It's so right. And it cracked me up how she was just like, oh, yeah, I killed this. I'm like... Do you not have a husband at home that can do the math for you? At least let you know that you don't go on the news. Don't go on the news and push this story. But then Brian Williams is out there doing shit too. So it's crazy shit. Okay, let's get to let's read this story a little bit. Let's read this story. Jay-Z. Okay, in a withering order published Thursday, a federal judge denied an effort by the Grammy-winning rapper, real name Sean Carter, and his sharp-elbowed lead lawyer, Alex Spirio, to see the allegations against Jay-Z and Combs dismissed. Judge Annalisa Torres also rejected the 99 Problems performer's hopes to see Jane Doe's real identity made public. Wow. And to move the whole thing along at a quicker pace, stressing the weight of the factors, including the highly sensitive and extremely personal nature of Jane Doe's claims. Torres has decided the context of the matter tips in favor of allowing plaintiff to remain anonymous, at least at this stage of the litigation. Interesting, the judge did acknowledge that her opinion on anonymity could change down the line, depending where the case and the evidence leads. As more suits, sordid accusations against Combs have come out over the past few months with details of his drug-fueled freak-offs and violence. A graphic October 20 filed lawsuit named the rapper and the rape of a 13-year-old girl at a party. Jeez. I mean, 13-year-old girl, at least Dana Stubblefield was hitting, of age women, right? And not just the mentally ill ones. Have you seen Hannity's new side piece? That was his Christmas bonus. Yeah, not impressed. She could have done so much better. In the legal atom bombs that have followed, one thing made clear from today's order is that Torres does not like the way Shapiro is conducting Jay-Z's defense so far. Okay. Carter's lawyer's relentless filing of combative motions and containing inflammatory language and ad hominem attacks is inappropriate, a waste of judicial resources, and a tactic unlikely to benefit his client, the judge wrote today, of the Quinn Emanuel partner and his methodology for his client The court will not fast-track the judicial process merely because counsel demands it. In fact, Alec Baldwin, Elon Musk, legal beagle Spiro's usual aggressive tactics are not doing this billionaire client any favors on almost any level with this judge. It's not reflecting well in his attacks on Jane Doe's own attorney, Tony Buzbee, according to Torres. Moreover, although Carter's attorney assails plaintiff's lawyer as having a chronic inability to follow the rules, Carter's counsel has failed to abide by the court's clear rules, Torres writes, about what has become a battle of the barbs between Spiro and Houston-based Buzbee, who's representing dozens of cases against the much-accused Combs. That sentence didn't make sense. Dozens of cases? I don't know. Skimming over Spiro's scattershot accusations about Busby's so-called misconduct and allegations, he is apparently attempting to avoid its disciplinary authority. The New York federal judges added, although Carter's attorney stated that he intended to file immediately a motion to strike the First Amendment complaint, a Rule 12F, he did not give plaintiff the requisite 5 business days to respond. See individual practices. Wait for the court to set a motion schedule or state whether an exception to the court's individual practices applied. This is unacceptable. Counsel is hereby advised that any further motions filed in violation of the court's individual practices may be denied on that ground alone. It goes on. I can't keep reading this shit. But what I think it is important to note is that maybe these people are starting to get their asses handed to them a little bit. And with that, you talked about Hannity. Let's go here. So, here we go. Fox's royalty, Sean Hannity and Ainsley Earhart. Okay, there they are. I mean, she's a decent looking older lady, right? He's going to be 63. Oh, wait, she's only 48. You dog. So, good for him, I guess. I guess he's been separated since 2015, officially divorced in 2020. And there they are. I don't know. I used to like Hannity. I'm just not a fan of his anymore. There you go. Judge explodes at Jay-Z. Okay. Pizza delivery worker stabs pregnant customer 14 times over a lousy tip. Trump shares cryptic messages intended for Elon Musk with the world. So there's all these things going on right now about, the H-1B whatever visa issue going on. I don't know if I'm even caring about that. I am trying to wait. Let's go back here. I have not seen Hannity since Hannity and Combs. Agreed. Wait, Hannity got a divorce? Yeah, because he was married, had 2 kids, and so he's 67 years old. He had been married quite some time. Evidently, they all get along, so it's not. I just saw him with some bimbo on Twitter yesterday. Yeah, damn, he got old. He did get old, but we are all getting old. And I think I'm going to cut it here. Just short of an hour. We've been streaming a little bit here, and I got that in. I got to talk a little bit, so I enjoyed that. And then we will have Tower Gang tonight. So I hope you guys all tune in for Tower Gang. Tyler is about to have Chinese grandchildren, maybe, and that's really none of your business, Andy. I like all my kids and their my son's girlfriend. So, yeah. Let's see if there's anything else on this. See, Blake Lively, we talked about that. You do need a right to permission to sue. So I talked about the DFEH and through California or the EEOC. Go back there if you want to talk about that. Biden, we'll do this last one. I'm not going to read it. I'm just going to talk about it. Biden appointed, evidently, I guess, like recess appointments, a bunch of judges here. And that's kind of the 235 judges appointed by Biden will preserve departing president's legacy. Great. What is that legacy? I don't know. Of course, he's dodging H-1B. Yeah, catch you later, Tyler. All right, guys. We'll see you a little bit. H-1B, am I dodging it? I just haven't really looked into it or care too much about it. I should probably care. I probably don't take the side of Vivek and Elon on this one. There's a lot of problems with the H-1B visa system. Okay, so, and yeah, I don't know. I haven't dug into all the crap with it. But until then, so anyway, the judges are getting appointed. That's what else you want to know. There we go. Let's see what we do for an outro. We'll do this. Anyway, I hope I feel better this next week. because next Wednesday we got New Year's, so I'll probably do a show in the middle of the week again. There's something good to talk about. Try to get away from all this reading because Andy just doesn't like all the reading. Death. I used to listen to him on the radio in the Iraq War, and I would get headaches. He called Ron Paul a cut and run Republican. I got something you can dig into. Okay, dirty boy. Yeah, but you wouldn't ever come on this show, you pussy. Big ass pussy. Anyway, everybody, hope you have a good weekend. Tire Gang tonight, 9/11. Eastern, 6/11 Pacific. I think we're gonna go there. I'm gonna go get some food and maybe see what we have going on. Until then.
I'm going to address Tyler Yankee again. He's our biggest hater. He's a fucking faggot. Pull that up. Wondering where the real Top Lobster was last night. Tyler, if you had any clout about you, if you had any like knowledge of the real world of what happens, we walk into Tim Cass' studio immediately. There's 4 Jewish lawyers, and they tell us sign here, initial, fingerprint, and then they give us a paper and they say you can't say anything here. Don't even try to be funny. Don't laugh. Don't look Tim in the eye. There's a lot of rules.
Yeah,
and I'm trying to do
there's
this.
a 3-second tape delay, and they say we will cut tape if you make any innuendo.
Yeah. There's a guy with a
Jays.
gun in the corner of the room, and he says, "Say something wrong, and I'll fucking shoot you." This is all new policy since Ye has been on.
Yeah, since Ye.
But there's an Israeli man